Hello everyone, this is Ed Park from ATMS Logistics. Today, I'll be explaining Section 201 Safeguard Measures, a trade remedy that is far less well known than Section 232 or Section 301, yet can be far more dangerous for importers. This video is especially important for those who often ask, I don't understand why a new duty certainly applies to my shipment. Going forward, we will continue to upload in-depth videos covering a wide range of import and customs related topics. So please like, subscribe, and turn on notification for future updates. Let's dive into today's topic. What is Section 201 Safeguard? Simply put, Section 201 is an emergency brake designed to protect U.S. industries, while Section 232 is based on national security concern. The Section 301 involves retaliatory tariffs for unfair trade practice. Section 201 can be imposed solely because imports increases too much. In other words, it has nothing to do with the unfair trade. It is not related to any specific country. It applies when a surge in import is considered to have caused or threatened to cause serious injury to U.S. industry. As a remedy, a government typically uses quota or tariff rate quota called TRQs rather than simple tariff. A tariff rate quota means imports within a specified quantities are subject to a lower duty rate. When imports exceeding that quantities are subject to a much higher duty rate. It is a trade management tool that combines quantity restrictions and differentiated tariff rate. This is why, from an importer's perspective, Section 201 is a penalty even when you did nothing wrong. Section 201 is based on the U.S. Trade Act of 1974 and WTO Safeguard Agreement under international trade law. There are three key conditions for Section 201 safeguard action. The first, as mentioned earlier, a surge in import. Import growth may be absolute or relative. A rapid increase in market share within a short period is often sufficient. The second, serious injury to U.S. industry. The U.S. International Trade Commission, called ITC, evaluates whether domestic production, sales, or profitability has declined. Employment or capacity utilization has decreased. Market share has been lost. The overall financial condition of the industry has deteriorated. Third, causation. The primary cause of the injury must be due to increased import. Other factors such as technologically change or declining demand must be distinguished. If all three conditions are met, a safeguard may be imposed regardless of fairness or country of origin. The safeguard process generally proceeds as follows. It starts with a petition filed by U.S. industry, often manufacturer or labor union. Then, the U.S. International Trade Commission initiate an investigation. Public hearings are held, and interested parties submit comments. The ITC determines whether the serious injury exists due to import surge. If serious injury is found, the ITC recommends remedies such as a quota or tariff rate quota. The final decision is made by the President. Once signed, the decision is published as a presidential executive order in the Federal Register. The safeguard then becomes effective. The entire process typically takes 6 to 1 year. The key characteristics of Section 201s are: first, global application, which means it applies to all countries, cannot be avoided through transshipment or origin change. Second, form of relief, additional duties, which are less common but more likely absolute quota or tariff rate quota, which is most common. Third, duration, normally limited to 4 years. However, it can be extended up to 8 years. Let's review a couple of representative Section 201 cases. The first, solar panel. The tariff phased down annually. High duties applied once quotas are exceeded. Certain developing countries were exempt in this case. The another one is large residential washing machine. Global quota regardless of country. Sharp duty increases once quota limits are exceeded. What matters most is when the quota is exceeded. Quota typically reset at the beginning of each year. Early in the year, lower duties are more likely. Late in the year, quotas are often filled, resulting in higher duties. Duties are determined by the time of entry, not by shipment date. For example, ship in December but enter in January, which means lower duty may apply due to quota reset. Three common misunderstandings about safeguard. The first, importer might say, it's not from China, so I'm safe, which is incorrect. Section 201 applies globally. It's from FTA country, so it is exempt, which is also incorrect. Safeguards are independent of FTA. We can avoid it by changing the country of origin. Incorrect. Origin change do not avoid safeguard. Safeguard focusing on how much is imported, not where it comes from. Let's review some practical strategies for importer. The first, pre-exemptive action is critical. Monitor ITC safeguard investigation. Include tariff adjustment clause in long-term contract. Recommended customs and clearance strategy. Track annual quota usage. Consider early entry strategy. Evaluate split shipment where feasible. Third, post-implementation options. Review limited exclusion possibility. However, this is very limited. Reassess pricing and sourcing strategy. Once a safeguard is in effect, options are extremely limited, and rapid response is essential to here. Today, we took an in-depth look at U.S. safeguard measure under Section 201. We will continue to upload detailed, practical videos on U.S. import and customs compliance topic. If you have any questions or need assistance, please contact us using the email shown on the screen. We'll be happy to help. Thank you very much for watching, and I will look forward to seeing you again in the next video. Have a great day.